Good afternoon, financial professionals. Abby Fletcher here of E4 Insurance Services, welcoming you to the BREW, Building Relationships Every Week. Thanks for tuning in today. For those of you joining the BREW for the first time, welcome. We like to start the BREWcast by celebrating today's National Day for August 25th. Today is National Kiss and Make Up Day, as well as National Banana Split Day. You know what this means, folks. Today we are encouraged to make amends with those that we may be quarreling and strive to compromise. Even better, it coincides with Banana Split Day. So perhaps treat you and your loved one to a banana split after you kiss and make up. Today on the BREW, as part of our advanced planning series, we have Susan Johnson-Drenth, who serves as certified elder law attorney and will be covering Medicaid. We here at E4 have the luxury of speaking with Susan often, but we wanted to share this benefit with you, our esteemed advisors. We have Susan reserved for an hour, and this BREW is being recorded and will be put up on YouTube this afternoon. Feel free to use the chat box down below to share your thoughts and questions while Susan is live. I'll be keeping a lookout. And then also all attendees are in a drawing for a prize and we'll be announcing the winner shortly. Thank you for tuning in. And without further ado, I'm handing the mic over to Dan Peterson, who serves as our president here at E4 to kick off our conversation with Susan.
Thank you, Abby. It's a great pleasure to bring today's speaker to you and the topic that Susan's going to cover. This is part of our advanced planning series, and we're going to go a little longer than our normal BREW, and we will have time for a Q&A at the end. So jot those questions down or put them in the chat, and Susan will take questions at the end, and I'm sure that you're going to find today's topic relative and informative. I've had the pleasure and enjoyed working with Susan over the past 10 years. I've seen her work with estate planning with high net worth clients that I've worked with extremely complex estate planning needs. And I've seen her work with clients with a spouse who's in a nursing home and they're trying to qualify for Medicaid and save that last little bit of their life savings. My wife and I have done our personal estate planning with Susan and her team. Susan is the only certified elder law attorney in North Dakota, and she has been named the Great Plains Super Lawyer for the past 6 years. She is a fellow in the American College of Trust and Estate Counsel. She's a former state chair for North Dakota and the chair of Elder Law section of the State Bar Association of North Dakota. Susan's practice areas include elder law, taxable estate planning, probate litigation, guardianships, asset protection planning, real estate, mineral rights, and trust law, including special needs trust for the disabled. Susan is a big believer in the liquidity life insurance and long-term care insurance provide in the financial planning process. She believes that planning is power, and that when one fails to plan, crisis management becomes the plan. Prior to becoming an attorney, Susan was a registered nurse. She still maintains her RN. And I have seen firsthand how this experience helps her with clients and discussions about end-of-life planning. So feel free again to use that chat box to share your thoughts with Susan. She's going to be we'll be keeping an eye out for your questions, and remember that everyone's in a drawing for a prize at the end. Thanks for tuning in, and without further ado, Susan, the mic is yours.
Well, thank you, Dan, for those nice comments, and thank you, Abby, for facilitating. I'm happy to do some teaching and probably with your questions do some learning today, as I understand that we've got a national audience. Medicaid and Medicare, of course, are both federal programs that integrate into the topic that we're talking about today. But Medicaid, although it's 50% federally funded, is uniquely managed by each state. And so I will be speaking on North Dakota today. What I've found when I go to national meetings is that North Dakota is somewhat restrictive compared to other states. And so you may find that some of these planning techniques are opportunities you can seek in your own states. As far as how to find a certified elder law attorney in your state, you may want to go to NAELA, which is acronym N like Nancy, AELA.org, which is the National Academy of Elder Law Attorneys, where you can do a search. And just as insurance agents or brokers can have different acronyms or initials after their names, so can attorneys. Anyone can be a member of NAELA, but to be a certified elder law attorney, you have to have passed a national test and have at least 5 years experience in peer review. And so if you want to make sure that the attorney that you're selecting on behalf of your client has that experience, you'd want to look for a certified elder law attorney, which you can search certainly in NAELA. So we're going to jump into some concepts and understanding Medicaid and maximizing the allowable assets and income for a community spouse is going to be our focus today. And we're going to go rather quickly, but please jot down your questions and I'm happy to go through them at the end. Not knowing what everyone's understanding is, of course, Medicaid is an eligibility program, whereas Medicare is an entitlement program. I frequently hear people mention applying for Medicare for the nursing home. Medicare you get because you're entitled to it, either after age 65 or if you're blind or disabled under 65. Medicaid in all 50 states, you have to prove you're eligible. And one of the big eligibility issues, of course, is getting your assets reduced. In every state, when we're talking about assets, we're obviously not talking about income. That's a different rule. And assets are going to have availability rules. And they're either going to be considered countable against you, also called available, or they're going to be called excluded. And if you can maximize the amount of excluded assets that count as zero against your client, they're going to be able to keep more in addition to just the standard limits. And so a single person in most states, it's $3,000 or less of countable available assets and any amount of excluded assets. If you're married in North Dakota, North Dakota is a 1/2 state, meaning all available assets are counted up when someone goes into the nursing home, and they're either treated as available or excluded, which we'll talk about in a moment. But the community spouse, the one who's healthy in the marriage, is allowed, in addition to excluded assets, 1/2 of the assets not to be less than $26,000 and change, and not to be more than $130,000 and change. North Dakota is a unique state in that IRA accounts for the community spouse are deemed excluded, but you have to meet certain requirements. And so even if I say had $1 million IRA and my husband was in the nursing home, I'm allowed to keep that IRA treated in a special manner in addition to the $130,380. And not all states are like that, but some states like Minnesota, as we'll talk about, have similar treatment, even though they don't have the same law. And then in Minnesota, it's the first 130,000. So in North Dakota and some states, you're allowed 1/2 of available assets for the community spouse. In Minnesota, you're allowed you're allowed the first 130,380. And the IRA accounts get no special treatment, but through understanding how the laws work, you can have the same result. And that's where, as insurance agents and brokers, you can really help your clients, because the counties will, when they're applying for Medicaid or medical assistance, the counties will not tell them some of their federal allowable options. Now, what are they count as countable in North Dakota? And sometimes this is different in each state, but obviously assets which you can get at, whether or not they come with a penalty, bank accounts, annuity balances, cash value of life insurance. And just as an aside, when a community spouse is trying to fund their $130,000 allowable bucket, if the institutionalized spouse, husband say in the nursing home, has a life insurance policy which has a cash value, if the power of attorney signed by the husband allows the wife to transfer that life insurance ownership to her, then she can retain that death benefit. And that cash value will then count against her $130,000. Too often individuals don't know they have that option and instead will cash the life insurance policy in.
No.
I'm sorry?
Other than,
Oh, okay. I think we're going to take questions at the end.
Yeah, I just muted there.
Oh, okay.
Yep.
And then a second vehicle, real estate other than your primary home, and then 529 college plans, they're available with a 10% penalty, so they still count as yours. And what are you allowed in addition? If you look at the excluded assets handout that should have been provided to you in North Dakota, that would, and in all states, that's going to allow a home. And as long as the community spouse, minor children, or disabled children are living in it. And in North Dakota, that can be up to 2 acres if it's in town, or up to 160 acres with your house, as long as your house is attached to it and is contiguous, if it's outside of the city. And in most states, you're allowed to transfer the ownership of that home to the healthy spouse, so that if it's sold in the future, that half of the home proceeds don't have to be given to the nursing home. Other things that are excluded are certain annuities, funerals, mineral rights in certain circumstances. But North Dakota is a rare state that will exclude IRAs. So when they're adding up how much the community spouse is allowed to keep, the IRAs are not a component of that math. They are allowed in North Dakota, the community spouse, to keep their IRAs as well. But they must, as you can see from the excluded assets handout at page 9 of 12. So the excluded asset handout at page 9 of 12 at paragraph 23. This is how North Dakota and a handful of other states allow IRAs to be kept by the community spouse. And first of all, they have to set it up into an irrevocable, unchangeable, unsaleable annuity. And it also has to have irrevocable beneficiaries. A key component here is most states will require that the life expectancy or the term of years be fixed, that it not be a term of years or life. And it's not the company's actuarial table that is used. Instead, it must be the social or the life estate table life expectancy table. I misspoke. It must be the life expectancy table set out in your state that you're applying, where your client is applying for Medicaid. In North Dakota, they follow the Social Security website, socialsecurity.gov/OACT. And you can find the table there, and then it sets out male or female and the term of years. The issue is, and I've seen this several times, is that if an IRA is annuitized according to a company's actuarial life expectancy, and that term is longer than the state's actuarial life expectancy, that's considered an irrevocable disqualifying transfer, which will delay or permanently stop any eligibility for medical assistance. And so this should only be done after consulting with an attorney regarding how the Department of Human Services in that state is going to treat this, and to make sure that you're using the right table. Then the North Dakota Department of Human Services or other state must be the irrevocable beneficiary, not to exceed the medical assistance benefits paid by both spouses. But after the Medicaid claim is paid in full, you should definitely always include contingent beneficiaries, especially with the bad results of a qualified retirement account going to an estate. And so not knowing whether or not that Medicaid claim is going to consume the entire IRA, always have backup beneficiaries. In North Dakota, if you refuse to roll over your IRA to an annuity, then there is no North Dakota Medicaid for your spouse. So it's either you have to cash it in or turn it into annuity. But as you can see from the rules, keeping the way it is not an option. Now, if you are still in employment years and you have a 401k and you're employed, they do not make you touch your 401k under age 65. There's some inconsistencies on what happens when you turn 65. Excuse me, just as a precursor to another thing we're going to be talking about, you want to grab a pen. On February 8th of 2006, so 2806, the Deficit Reduction Act of 2005 was signed by President Bush. That allows SPIAs to be done in addition. when you're seeking medical assistance eligibility. And that's something that Dan and I have been lucky enough to help clients with repeatedly. And this is federal law. It has to be accepted in all 50 states. I know I've had a difficult time getting North Dakota to accept it, but they've acquiesced. And so you can set up extra assets above and beyond the $130,380, even if they are not in a qualified retirement account, into a single premium immediate annuity. And that will, as far as federal law goes, the community spouse can have that income source as well. And we'll be talking more about that later. But with annuities, you need to always be there for your client, because the client is held to the burden and the standard of being able to explain to the county and the state level, what exactly is this account? Is it an annuity? Is it annuitized? Is it life insurance? When did you change this type of product? And that has to be presented to them along with the contract and all the beneficiary forms. And in most states, there has to be a notice given to the state specifically at the time of applying for Medicaid when you give them the contract and the beneficiary forms. If it is not an allowable SPIA, so if it's just a deferred annuity contract, and it can be sold on the factors market, then North Dakota and Minnesota and other states that I know my peers practice law in as well, require that annuity contract or annuity stream, if it can be sold or assigned, to be offered to at least 3 companies. And you have to be willing to take somewhere between 60 to 75% of the value of the annuity from the company as payment. And to essentially reduce the applicant or their spouse to liquidity to be able to pay for their care. And so if it's possible, oftentimes you'll want to convert those into SPIAs. Otherwise, they do have to be sold. And the only company that I've ever seen buy them in North Dakota is J.G. Wentworth. As we talked about, if your life expectancy at your company is longer than the MA rules allow in your state, it's considered a disqualifying transfer, because the state, excuse me, it's been smoky and hazy here. It's considered a disqualifying transfer because the state is saying that under their rules, the individual, the applicant or their spouse will likely never see the return of the entire annuity because you extended the term too far. And as we talked about, the community spouse can keep extra assets in addition to their baseline $130,000, which is a federal number, irrevocably annuitize them and keep the income stream. And it doesn't have to go towards nursing home care. Here's an example. I'm just going to take a minute and have you look through this as I'm explaining it. The right-hand column, the excluded column, is where you want things to be, because the bottom line on the excluded column is it counts as nothing. All of those assets are considered excluded in North Dakota. The home, her IRA, the joint checking account, that's considered available, and some states call that countable. The husband's prepaid funeral, as long as it meets the state's requirements, that's very unique per state. Their old car, their household goods that are not titled or in a DMV, Department of Motor Vehicle database, and then their big joint investment account. And so when we're determining how much the community spouse is allowed, she's allowed all of those excluded assets as long as they're treated in a certain manner, plus she's allowed 1/2 of the available assets, of which are $220,000. So her half will be $110,000. Now we're going to use husband's power of attorney to transfer the house title to her name only. She's allowed all of the household goods and car, and she's allowed to have her name on the $3,000 joint account with her spouse. And then the husband is allowed his name on the joint account as well, and the prepaid funeral. But she's going to have some money to get rid of. She has $220,000 that's counting against them. She's allowed to keep $110,000. Her husband's allowed to keep $3,000. She still has what is referred to in most states as excess assets of $107,000. She's allowed a home. It doesn't have to have a mortgage on it. And so she's allowed to pay off that mortgage even though the husband's name is no longer on the home. The home is an exempt federal asset. And she's going to buy a new car. Now, the new car value is going to be specific per state. In North Dakota, with our blizzards and things, they wouldn't even blanket a car for $20,000. Then we're going to deal with her IRA. It's excluded, but she can't keep it in its current condition. She's going to have to alter the way that it's handled in order for it to comply with North Dakota's law and with the Deficit Reduction Act of 2005, signed into law on February 8th of 2006. So in this example, it's very simple, okay? She's obviously, it's going to be more complex than this, but she's 70. According to the Social Security website, her life expectancy is 180 months. And so if she irrevocably annuitizes her IRA for 180 months, she will have that additional income stream of $1,100 a month. Now, under federal law, once her husband is on Medicaid or medical assistance or Medi-Cal or what it may be called in your state, his income is up for grabs. In some instances, some of his income, if she is low income, can go to her. But essentially what I mean by up for grabs, his income is going to have to go to help pay for his care in the nursing home as a copay or client share before Medicaid starts paying. Her income, once he has his Medicaid eligibility card, is hers to keep. Whether her income comes from Social Security, whether it comes from a pension, or whether it comes from an annuitized IRA or the income stream of a SPIA, she's allowed to keep that. And you're probably thinking, does she have to keep herself at $130,000? No, she doesn't. She only has to be at that $130,000 the month she gets her husband eligible for Medicaid. At that point, she can continue to save money and increase her holdings as long as her husband's name is not on any of the accounts. Now, Minnesota, just to compare and contrast, and your state might be different as well, the single person asset limit of $3,000 is federal. So that's going to be in Minnesota as well. You can't keep and annuitize IRAs as a single person. Minnesota, if you have real estate in a life estate, there is a lien against it. And a community spouse is allowed the first $130,000, it's not half. And you can annuitize IRAs and excess assets like in North Dakota. And then the life estate lien law exists as well. Another question, can you pay your children to take care of you? In North Dakota, there's something called a personal services contract. Now, this is going to be unique in each state, but while you're counseling your clients on what they can legally do with their assets, when it's past the opportunity to gift them away, it's beyond it's too close, they need to get Medicaid, they can't wait a 5-year look back period, and you're thinking of a way to do it in North Dakota and in Minnesota, you can sign a personal services contract. So if children or grandchildren are coming over to help maintain the autonomy of an elderly or disabled person in their home, so they don't go into the nursing home, and they're taking time away from work and their family to do so, then they can certainly be paid to do that under a personal services contract. Of course, it needs to be market rate of what a home care company would charge, but that's perfectly legitimate as long as it's done to meet the requirements of your state statute and your medical assistance rules. If the care is not paid under the terms of a written contract, Medicaid or medical assistance will likely think that it's a gift. And under federal law, any gifts that were given within 5 years of applying for medical assistance will cause a disqualification period for medical assistance relative to how much was given. Under a personal care contract, of course, the child is going to be paying income tax because they're likely going to be earning much more than the limit of $600 per year. How do you pay other people for mowing your lawn, cutting your hair, running errands? What I recommend to clients is, so that it doesn't look like a disqualifying gift where you're writing a check to Barb, the lady who does your hair, and they think it's just a gift to Barb. Well, if she does your hair, gives you your perms and your haircut, whatever it is, pay by check to help explain the transaction, and then use the memo line. So if this is the woman who comes in and does your hair, then put on the memo line. hairstyling, whatever it might be, so that there's a record of that. And then don't round up. If they see in North Dakota, for example, it's not unusual for them to ask for 5 years of canceled checks, and in Minnesota as well. And if they see checks for round numbers to individuals, they'll just assume that was a gift or portion of a gift. And so if your son goes and picks up $83.70 of groceries, pay him exactly that and keep the receipt, especially in states that it's common to have to produce 5 years of canceled checks and financial and bank records. Don't round it up and then use the memo line. So what all happens when you need to apply for medical assistance? In every state, the medical assistance application is going to require that you disclose all uncompensated transfers made within 60 months before the Medicaid application. So if I was completing an application for August of 2021, then I would have to disclose any time that I gave away for free, even if it's a Christmas present or birthday present or money in the church plate, or sold for less than fair market value, any assets since August of 2016. And what the state will do is add up all those gifts that your financial worker is willing to dig into. Each county, in my experience, I've been doing medical assistance applications for 24 years. Some counties don't want to know if it's $200 or less. Some counties want to penalize if it's $20 or more. And so you kind of have to get a feeling of what they want to know about it. But they'll add it all up that was given away in the last 60 months. And that amount will be the numerator in a calculation. The denominator is something called the SAP-SNF rate, SAP-SNF, like Frank. And that's a statewide average per day or per month cost of care within the state. Essentially, the Department of Human Service in that state must determine an average cost of long-term care per month. And that's the denominator. And so if the gift was $100,000 total in the last 60 months, and the denominator, the average cost of care in that state is $10,000 a month, then at the time of applying for medical assistance, there will be a 10-month disqualification period imposed. Now, mind you, you cannot apply for medical assistance until you as a single person are down to $3,000 or less in your name. Or if you're married, that your institutionalized spouse is down to $3,000 and the community spouse is down to their limit. So by definition, you have no assets to be able to pay for this 10 months of disqualification. So if I was a single person and went into a nursing home and I had $1,500 to my name, and I disclosed that I gave $100,000 away cumulatively in the last 60 months as the numerator, and the denominator, the SAP-SNF rate is $10,000 per month average cost of care, I'll be told, yes, Susan, you're eligible to get medical assistance 11 months from now. How you pay your bill for the next 10 months with your $1,500 to your name, that's your problem. And North Dakota is a filial, F like Frank, I-L-I-A-L state. Not many states are, but in North Dakota, the county and the nursing home have the right to sue the children that received that $100,000 in the last 60 months if they will not return it to pay for that 10 months of care. There is now standing to go after the donees in the state of North Dakota to return that and to be reduced to judgment and go after the children, even if they don't live in the state of North Dakota. And if you get caught lying on the medical assistance application, it is a crime in every state. It's the unauthorized receipt of welfare benefits. And depending upon the state's laws, when you're talking about $10,000 a month in medical assistance, quickly that's going to become a felony. And so if you're giving presents or gifts away to your children, or your client is, of let's say $100 for birthdays for per person, $100 to the grandkids, $100 at Christmas time, $500 for a wedding, that type of thing. And then you check, no, I didn't give anything away in the prior 60 months when you apply for medical assistance. In all likelihood, it's not going to be you that's applying for medical assistance. It's going to be your child that's the power of attorney. And if they got caught lying, trying to hide the fact that they've received $100 a month or $100 a year at Christmas time, they could get caught and be actually prosecuted for that. So it depends on your state, but increasingly, I'd say 1 in 3 cases in North Dakota and Minnesota, we have to provide 5 years of bank and investment records, 5 years of canceled checks, and 5 years of detailed explanations on how large ATM withdrawals were spent, especially if they big ATM withdrawals in December, because they just assume a lot of money was taken out, and usually at the beginning of December, it must have been for the holidays. And any county financial worker, this is what they do, 40 hours or more per week, and they're going to find ways to figure it out on what you've been giving away. And what if your spouse becomes incompetent and cannot sign the papers to meet the MA rules, like annuitizing their IRA or deeding the house to the spouse? Every state has 2 alternatives of taking care of the financial matters of an incapacitated or incompetent person. Number 1, before becoming incompetent or incapacitated, they can sign a durable general power of attorney and list the individuals and grant the authorities regarding gifting or whatever it might be, or transferring assets within that power of attorney, and then just set it aside until they become incapacitated and will be used. That's the smart way to do it. But if they don't have a power of attorney in place, at the second bullet point, you can see then there's going to be a court proceeding. And in some states, it's called guardianship. In some states, it is called conservatorship. But then the judge is going to decide what can be done. And remember, judges are paid by the state. Medical assistance pays at least 50% of its burden under state funding. And so frequently judges are going to say, no, I think if the house sells, we'll want half the money to go to the nursing home rather than all of the money to go to the community spouse. And so if you want a greater opportunity in your planning, the proper powers of attorney should be done by an elder law attorney, not just an attorney that does wills, but an attorney that knows the language that's required to be able to protect assets in the future. The power of attorney, of course, is separate from the personal representative in your will. You need a will and a power of attorney. And then also at a time when a spouse is declining in health, or if it's immediate, going into the nursing home. So if you see it coming and they've got Parkinson's or Alzheimer's or dementia, and spouse is taking care of the declining health spouse in the home, the time to start planning is now, before the individual sets foot in the nursing home. Crisis planning can be done at the same time, but you can usually protect more if it's done in advance. And part of that planning, and it's a tough conversation as an estate planning and elder law attorney to have with my clients, but part of that planning is I ask my community spouse, the healthy one, who's caring, let's say it's a wife, who's caring for her husband with dementia, if you were to die today, would your husband be able to live independently at home or receive home care? And if the wife tells me, oh no, if I died, he'd have to go into the nursing home, then that's the time to start thinking about minimizing inheritance to this spouse with dementia. And under the law, there has to be something that goes to your spouse unless you have a prenup. And so you can't get around that. There has to be a minimum elective share going to, in this case, your husband with dementia. But not everything has to go. And so if this couple had an old will, and in the wife's will, it just said, when I die, I want everything to go to my husband. And the house was jointly owned with the husband. So if wife dies, it'll go to the husband. And the bank accounts and investment accounts are all joint with the husband. And all the IRA beneficiaries and wife's life insurance beneficiaries all go to the husband. Then the wife should be counseled about how much she actually wants to leave to her husband if she was to pass away and he's going to go to the nursing home, and meet with an elder law attorney who knows his or her state's law, so that counsel can be given on how to minimize the inheritance legally to the institutionalized spouse in case the community spouse dies first, such as changing beneficiaries and updating the will and deeding the home away to the healthy spouse. Okay, before we go all the way to the end, I do want to touch on some of the handouts, and I believe those should have been provided as well. I'm going to go to the packet regarding annuities.
Yeah, in the chat, there's a link to the handouts that they can be downloaded. If anyone doesn't have that, look in the chat. Danielle has posted those. Okay,
thank you, Dan and Daniel. And so again, I reviewed it rather quickly, but February 8th of 2006, was the big shift in medical assistance eligibility nationally. And what everyone remembers that law for is it shifted the 3-year look back period for disqualifying transfers to 5 years. And the B side, if you want to say, of that law was SPIAs, single premium immediate annuities. When that law first passed in 2006, I spoke with my friends at the state in North Dakota and said, great, let's do SPIAs. And the state of North Dakota declined to do so. And they said, no, we're not going to follow that part of the federal law. And they are my friends, they work hard, but they sit on one side of the table and I sit on the other. And they act on behalf of the taxpayers to reduce payouts for medical assistance, and I'm trying to get medical assistance. And so we have to respect our positions. But I had to kind of scratch my forehead and say, well, how can North Dakota get its federal funding for medical assistance if it's not going to follow federal law? And for those of you in some states that are saying, we can't do this in our state, I just want to bring you through some history of what happened in North Dakota. And I'm doing it from memory. Obviously, I don't have the case sites in front of me. If that's something that you're interested in, I could certainly dig it up. It's been quite a while. But when this law passed federally in 2006, allowing the community spouse to keep assets in addition to the house, the car, and the back then around $100,000 allowance, which now with the consumer price index is up to $130,000. This law allows extra assets to be kept, and they don't have to be IRAs. Now, what happened was there was a case in central North Dakota, and I'm just going to simplify the facts, but a woman and her husband had approximately $500,000 in assets, a house and a car, and husband went to the nursing home. So wife was allowed to keep the house, she was allowed to keep the car, and back then, let's just say she was allowed to keep $100,000. That was her max. So they had $400,000 excess. And her attorney, very learned attorney, was a perfect case to challenge the fact that North Dakota wasn't following federal law on SPIAs. And so that attorney took that $400,000 and purchased a SPIA in the wife's name with the appropriate life expectancy, and then went and applied for medical assistance and said, the husband's down to $3,000, the wife has the house and the car, and she's got $100,000 in her name. And then she's got her sources of income, which are none of the state's business because she's allowed to keep them. And the state of North Dakota denied the Medicaid application for her husband and said that that transfer of $400,000 into a SPIA was disqualifying, even though it met the federal law. And she then appealed that, and in the district court lost as well, from my recollection. At that point, she sued the state of North Dakota itself in federal court and said, you're not following federal law. And the state of North Dakota lost in the federal district court. North Dakota appealed it to the federal appellate court and lost as well, and lost in such a manner that the judge ordered that the state of North Dakota pay this woman's attorney's fees, which are in excess of $100,000. And so in that, North Dakota acquiesced to the 2006 federal law that allows SPIAs. Minnesota saw what North Dakota was doing and actually codified it in statute that you can do SPIAs. And so for those of you that maybe haven't heard of this concept before and see opportunities for your clients and able to keep additional assets, you might want to turn to the laws in Minnesota that were passed after North Dakota lost its federal case. And North Dakota doesn't have it codified to the extent that Minnesota does. Minnesota has a pretty nice job explaining it all. North Dakota has an administrative code and Department of Human Services manual that's a little bit muddy to go through, as you can see from the handouts here. But as Dan can probably attest to, we have helped people save in the millions of dollars of assets. One instance I can think of with Dan, a woman through different annuity products, wasn't she able to keep more than $700,000 in addition to her $130,000 allowance? Dan, wasn't it something like that?
Yes, it was. Yep, it both between qualified and non-qualified, it was over 700,000.
And there, it was such an important thing to do because, as I recall, there was quite a disparity in her age. She was quite a bit younger than her husband. And to have to think that she would only have a house and $130,000 in a car the rest of her life was a harmful idea. And so we were able to annuitize her qualified retirement products, as well as set aside some of their liquid assets, move them into her name, and then purchase a SPIA in her name. And now her husband's on Medicaid, and she's enjoying this monthly income that's coming to her and will come for her lifetime. So at this point, I think it might be a good idea to open it to questions, Dan.
Yeah, we have a question here. Do you think that states as well as hospitals will look to the filial laws to seek dollars from children?
Oh, it's already happening, actually. There have been a couple of cases in North Dakota that have actually made the front page of our biggest newspapers, where North Dakota is using this law as the vehicle to get to children. Previously, North Dakota's filial law went back to right after North Dakota became a state in the 1800s. And it was a simple couple of sentences that said children are responsible to pay for the care of their parents. And of course, that 1880s law predated Medicare or Medicaid or Social Security, and essentially just said your kids have to take care of you. But then that morphed within the last couple of legislative sessions in North Dakota to be a vehicle now to go after children that have received gifts in the last 5 years from their parents and are refusing to give them back. And so, yes, they're seeking judgments and have been successful in getting judgments against these children, whether or not they received a lake home, farmland, mineral rights, or liquid assets. And they're being returned because the person can't qualify for medical assistance because they're within the 5-year look back period. They don't have enough assets to pay their own bill. And so North Dakota is going after the ones who inappropriately took assets. As an elder law attorney, I don't just do what clients ask, just like you don't in your jobs. I look over the situation, and when there's assets to be gifted, I need to make sure that my client has a way to self-pay for 5 years. And I let their comments of, don't worry, I'm never going to the nursing home. If that ever happens to me, take me out to the back 40 and shoot me. My kids will always take care of me. I'm never going to the nursing home. And my pat answer is the nursing home is full of people that said that. And so I will not ethically help you move more than you can. And you need to have enough cash flow, long-term care insurance, or other resources to get through that 60-month look-back period. Then we can talk about giving more. And so I encourage long-term care insurance and require it in some instances to get through the 5-year look-back period.
Very good. There's a question regarding the beneficiary designation on SPIAs. And I know North Dakota has made a change in the past couple of years from how we used to do it. They become the irrevocable beneficiary, and I think you always write it up as their interest may appear, correct?
Yes.
And then the spouse, the community spouse, the non-institutionalized spouse is the contingent beneficiary.
Correct.
Is that still applicable?
Yes, and it's in your handout for annuities, and if you want to jot this down, it's the policy that talks about annuities purchased or changed after February 8th of 2006. That's that law change date. And it's on bottom of page 1. And it talks about the department is named as the remainder beneficiary in the first position for at least the total amount of Medicaid paid on behalf of the annuitant or the annuitant spouse. Or the department may be named as the remainder beneficiary in the second position after the community spouse or minor or disabled child, and is named in the first position if such spouse disposes or gives away of that annuity. And so commonly when Dan and I are setting up beneficiaries, we'll just do primary Department of Human Services as its interest may appear, then the spouse. And if spouse isn't living, then whoever they want their children or whoever they want it to go to. I don't delve into the second opportunity of being able to name the community spouse in the first position very often because I'm concerned about that the state has to be named in the first position if the spouse or child disposes of such remainder for less than fair market value. How would you possibly put that on your beneficiary forms to say that it goes to the spouse, but if the spouse is going to give it away, then it actually should have gone to the state. And I'm not sure how that can be met on the forms with any company.
question comes in, for a family that has a history of gifting money to their children, does the 5-year look back still apply?
Yes, it does. And it's a common question. I can have super educated, overly educated children and parents in my conference room talking for 2 hours about what the gifting rules are and what we can and what we can't do. And then in passing, as we're leaving, this is a common comment I'll get. But the gifting doesn't apply to that $15,000 you can give away every year, right? Medicaid doesn't affect anything. And as you know, we each have an annual exclusion under the gift tax rules of the IRS. We can give $15,000 of present interest value, something someone can spend right away, to anybody, anytime, and we don't have to file a 709 gift tax return. But that's the IRS. And if somebody's applying for medical assistance in a nursing home, the IRS rules are irrelevant. And so the IRS may not care if you give $15,000 or less per person per year, but medical assistance says, take that $15,000, that's the numerator, divided by the average cost of nursing home care in your state as the denominator. And the answer is how many months that $15,000 made you ineligible. And so 15,000 divided by an average cost of 10,000 would be 1.5 months. And in most states, it's a roundup. And so for every 15,000 you give away, it could result in 2 months of ineligibility for nursing home care if you try and seek the Medicaid eligibility. But I have seen no state, and I go to national meetings. I was the chair for ACTEC, American College of Trust and Estate Council, and as the only North Dakota certified elder law attorney, I represent North Dakota there too. And when I talk to my peers at national meetings, I can tell you the fact that there's been a history of giving, unless it's to a special needs child, which is an exception, but unless there's a history of giving to people, they don't care. That's all disqualifying transfer. If there's a history of giving a modest amount to church monthly or weekly, most states will look the other way. As long as it wasn't a huge balloon gift right before you entered the nursing home, maybe $10,000 to the church building fund so that it doesn't go to the nursing home. That, of course, would be egregious and would be considered a disqualifying transfer.
Okay. Question regarding the home as a protected asset. Could someone with a $300,000 home sell that and go buy a $600,000 home, and now the $600,000 home is protected for the community spouse?
If you look up home equity limit Medicaid under Google, it's going to tell you that there's some amount, probably ranging between $650,000 or $850,000 as a home equity limit. But that is the home equity limit under federal law for a single person. So if the person is at home receiving Medicaid in an affluent area, if they have $1 million home and they're down to $3,000 or other exempt assets and they're having Medicaid come in their home, that home might be too expensive. And so they have to sell and downsize. But if we're talking about a community spouse, so a married individual, they're allowed a home of any value. And so they could sell a $300,000 home and sell their $1.5 million farm and go buy a $2 million home if they wanted to, as long as it's in their name and they don't add another child or anybody else's name to it, which would be disqualifying. And so as long as it's a married situation, in the states that I'm familiar, there is no home equity limit. The community spouse is allowed a home of any value. If it's a single person, they're going to have home equity limits in each state, and that's going to be dependent upon the real estate value and what's published by the Department of Human Services.
Okay. From central Minnesota, we've been allowed with counties to allow to prepay children's funeral expense and irrevocably assign the funeral home and allow to deduct assets before entering medical assistance. Have you heard of that and your thoughts?
Yes, Minnesota's pretty liberal for the prepaid funeral requirements. And so I have heard that in other counties as well in Minnesota. It's pretty automatic if it's a special needs child that you're prepaying a funeral for, but even you can have unlimited burial space items, whether it's, the word escapes me, not where your cremains go on a wall. I forget what that is. So you can buy a bunch of those you know, at the cemetery where there's essentially people, you know, like a mausoleum type of thing. You can have unlimited burial spaces as long as it's your family members, either spouse or children. And then some counties extend that to even prepaying funerals. And if it's money that's either going to go to the nursing home or helping your family out and prepaying a funeral, why not help your family out as long as the county's going to allow it?
Yep.
And it doesn't have to be purchased through the funeral home. Oftentimes I'll work with the individual's insurance agents to prepay those funerals. But Dan, you could probably speak to some of the specifics on having to have the contract written by the funeral home.
Yep, we have National Guardian Life, for example, that has a prepaid funeral trust, and it depends on the state. Right now, they've suspended sales in North Dakota because the language was written probably by funeral homes that lobbied and changed the language so that those are challenged right now in North Dakota. But in Minnesota, we do have products that can be prepaid and extend to even family members. So additional assets can be protected, not have to be become excluded.
And just to follow up to that, on page 7 and 8 of the excluded asset handout is North Dakota's rules on funerals. And on page 8, you'll see the reason why National doesn't want to write in North Dakota anymore, because it's regarding a contract between the individual and the funeral home has to be executed as well. And so what I find when I go to national meetings is North Dakota is usually the most restrictive state compared to any of the other 49. And so sometimes people look to see what's happening in North Dakota to see if it might be coming to their state, and hoping that it doesn't.
A lot of the tools that we have available, and many times in the financial planning process, the home is the largest asset, and so reverse mortgages are now part of creating retirement income for individuals. How are reverse mortgages handled in applying for medical assistance?
The value of the home is excluded anyway, as long as either the community spouse or institutionalized, in that instance, it would be a home and community-based spouse, are living in it, or minor disabled child. And so the fact that it's losing equity is rather irrelevant. I'm not a fan of reverse mortgages because of the exorbitant fees. I know they have a wonderful purpose for a certain population, but what I find is there can be other opportunities to generate income. And that should be a last ditch option, in my opinion. But I know people that have them and love them, and it doesn't disqualify someone for medical assistance, but as far as trying to shelter real estate, transfer title, it may tie your hands because you're going to be at the mercy of the mortgage company.
Okay. If anyone wants to unmute and ask a question, feel free. I know that, Susan, we were talking amongst our team, one of our employees had their mother at age 62 need to go into a memory care facility with dementia, worked through the medical assistance process on his own, did not realize that there was assistance available from a certified elder law attorney. And it was a very painful process for he and his family and to qualify and to go through that process. And he so recommends that he wished he knew about the elder law attorney and how that really, I've always said, when you fail to plan, it becomes crisis management. You say that as well. And so many of the people who are trying to qualify for medical assistance are in that crisis mode. So some good comments there by one of our staff.
Thank you.
Anything else? Any other questions? Well, hearing none, we have a drawing. So if we could, Susan, if you could pick a number between 1 and 43.
13.
13.
My lucky number.
Who is Jennifer Schmidt is today's winner. She will be getting a Starbucks gift card and also a CE credit to get some additional CE. Thank you for joining this today, and appreciate that, Jennifer. Susan, it's been great. I so appreciate your knowledge and your skill in walking through all of these challenges. I also appreciate having heard you say how important insurance, life insurance, that liquidity that it creates in the estate planning process, that instant liquidity, as well as the long-term care. You've been a great advocate for the product and planning we do, and we really appreciate you. And thank you for being on today's BREW.
And if anyone would like my assistance in finding an attorney with some credentials in your area, just give me an email and I'm happy to help you do a search.
Thank you, everyone, and thank you for attending today's BREW.
Bye now.